All right. Well, welcome everyone. Thank you very much for joining me. I'm Lior Samfiru, the employment lawyer, and I'm here with you live right now, live answering your legal questions, your employment law questions. So again, my name is Lior Samfiru. I'm one of the founding partners of Samfiru Tumarkin LLP. You can find us across Ontario, across British Columbia, and across Alberta. And if you live in one of those places, if you have questions about employment law, if you're wondering about your rights in the workplace, man, oh man, are you in the right place? I'm here live. You can type in your question and I can answer it for you right now so that you know what to do. You know how to deal with that workplace problem. Maybe you've been given an ultimatum. Maybe your boss is telling you have to do something and you want to know if it's right or not. Maybe your job is changing. Maybe it's your hours, your pay. Maybe you've been demoted. What to do? Maybe you're being mistreated, bullied, harassed in the workplace. Can that happen? What should you do? Maybe you even lost your job. If any of those things or anything else applies to you, you're in the right place. You can ask me, Lior Samfiru, a question. I will see it, I'll read it, I'll answer it, and you can walk away with that knowledge and that information. We're here completely for you at your service, wanting to make sure that you have all the answers that you need. So watching is good. I know a lot of people watch this just to kind of learn. That's amazing. But you know what's even better? The better is to be the second voice on this session. And you do that by asking your question of me, giving me that opportunity to help you. And when I help you, I'll be helping others that are watching as well. Now, before I get started with today's questions, let me give you some other contact information. If you want to connect with me and my team off air, off social media, you want to have a private chat or a private email exchange, here's what you do. All you do is you go to employmentlawyer.ca. You see that address right here actually, employmentlawyer.ca. You'll learn a lot about employment law if you want. There's also phone numbers there, email addresses there. You can complete a form if you prefer. All the ways to contact me and my team are right through employmentlawyer.ca, right there for you right now. So take advantage of that. Make sure that you have that accessible, whether you need it now or you may need it later on. But right now, for the next 30 minutes or so, I'm live. You have time to ask your questions. You have time to get me to help you. It starts by typing in something on that screen there, pressing the enter button, and I'll see it, I'll read it, and I'll answer it. And I would do it right now. Don't wait till the end of the session. Oftentimes people wait till the end of the session, and then I run out of time and I don't get to answer the question. Don't let that happen to you. You can take your time right now and ask the question. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I'm going to do what I came here to do right now. I'm going to start answering questions, but ask yours. All right, let's see. First question from Tish. It says, I love the channel. Thank you. Am I still entitled to full severance if I volunteer to be laid off? The organization is currently laying off people. Any penalty for volunteering? So if you're telling your employer, hey, if you want to let someone go, I'm happy to be one of those people, and then they can decide whether to do it or not, then yeah, they absolutely have to. If they then decide to let you go, they have to pay your full severance. Absolutely. They don't get to say, well, because you said you want to be one of the people, now we don't have to pay your full severance. Nonsense. If they decide to let you go, the reason why they decided doesn't matter. Maybe they decided because they felt like it. Maybe decided because they're restructuring. Maybe they decided because you volunteered. Either way, that means they have to pay your full severance based on your age, your position, and the length of your employment. They don't get a discount. Now, that's very different than if you were to say to them, hey, I'm resigning, but I want you to pay me some money. No, at that point, you're resigning. They don't have to pay you anything. But if you're saying to them, if you're going to let someone go, it may as well be me. Sure, that's fine. They don't have to do it. But if they do it, they have to pay you your full severance. So Tish, good question. If you don't, well, if they do let you go, whatever they offer you, I want you to connect with me right away. And this is true for all of you. If you're being let go, chances are whatever you've been offered is a lot less than what you're actually owed. It's a lot less than that. It's true for 90+% of people. So what do you do if you're let go, whether you've been there for a year or 55 years, you contact me right away. You could do that through employmentlawyer.ca. All right. Thank you for that question, Tish. Appreciate that. Let's see. Next question comes to us from Michael on YouTube. one of your team members that I connected with tells me that Alberta does not have severance pay requirements after being laid off. Is this true? No, you were never told that, Michael. Or you misunderstood what you were said. Of course, Alberta has, not only do they have severance pay obligations, they have the exact same severance obligations as they do in any of the other provinces. We literally help thousands of people in Alberta every year get their severance. So if you lost your job, whether it's a temporary layoff, it's a permanent layoff, it's a termination for cause, yes, you are owed severance. You got to call us. So I think there was a misunderstanding there. Certainly that was not what you were told. Thanks for that, Michael. Taylor asks, I was on a 6-month sick leave. I was cleared to return to work, but my employer then requested a lot of information from my doctor and suggested that I might need an additional assessment. They then refused my accommodation request, saying that they were too severe. What can I do here? And this is a very common situation, unfortunately, but none of this is legal. Number one is your employer can't demand personal information. They can't demand to know what your condition is or what treatment you're getting. The only thing they're allowed to know is, can you work, can you not work, and what are the restrictions? They also cannot demand that you get another assessment. So none of that is legal. They have to follow what your doctor says. It's as simple as that. They don't get to hire another doctor to get a second opinion. It doesn't work that way. If your doctor says you can work, but you need A, B, and C restrictions, now they have to make it happen. They have to find a way to accommodate you. Now, in terms of being too severe, the restrictions being too severe, they have to accommodate even if it's not easy, even if it's problematic, even if it's costly. They have to find a way to accommodate. Even if it is hard, they have to accommodate. Now, at some point, it could be too severe. In fact, that maybe your restrictions are so severe that there's just no potential job for you. Unfortunately, in my experience, oftentimes companies say it's too severe when it's really not. They just don't want to work hard enough. Obviously, in your situation, Taylor, I don't know anything about your restrictions. I don't know anything about your company. So the best thing to do is to contact me off air. You can do that through employmentlawyer.ca. And I want to understand more. Chances are that they haven't met that duty to accommodate. Very, very common. So an important message and lesson here for everyone. If you need accommodation, modified duties or modified hours, maybe working from home, you need that per your doctor. The company has to make it happen. And in most cases, they're not able to say, no, we're not going to do that. If your employer does that, if they don't accommodate, let me know. Oftentimes, just a letter from me makes it all better, changes everything right away. See how quickly they accommodate you once they hear from me. Okay, so reach me through employmentlawyer.ca. Great question. Thank you for that, Taylor. See how easy it is, everyone, to ask questions. You can do the same thing, like Taylor, like Michael, like all those good folks. Ask your question right now. For those joining us, my name is Lior Samfiru. I'm the employment lawyer with Samfiru Tumarkin LLP. Find us across Ontario, British Columbia, and Alberta. Right now, I'm here live for you at your service, answering your questions. So ask those questions as well. All right, continuing. Great questions today from Jenna. Working continuously for a car dealership for 7 years, now in my 8th year, sales manager position since 2019, let go without warning, without cause, asked to come back after at a lower position. Basically, they're saying you can stay as a salesman, but you are no longer a manager. So no, it doesn't work that way. They don't have a right to demote you. And I think you're saying you're asking for your husband. They're not allowed to demote your husband. They're not allowed to take away that managerial responsibility. So by doing that, they've terminated his employment. We call this constructive dismissal. Constructive dismissal happens when you're demoted, in this case, when they change your job significantly. So your husband now has two options. Option number one is he can accept the demotion if he wants. Of course, he can do that. I'm not going to tell him he's not allowed to. But he has a second option. And that second option is he can treat his employment as being terminated. Now he can get severance. So if he's been there for 7 or 8 years in a managerial position, he could be owed as much as a year's pay, 12 months pay. So those are the options. Accept it and you're a salesperson now instead of a manager, or you treat this as a termination of employment and get severance. Those are the two options. There's not a third option. So what your husband needs to do is this. If he wants to If he doesn't want to accept this demotion, if he just wants his severance and to move on, then he needs to call me, okay? Or he can email me. You can do that. He can do that through employmentlawyer.ca. You see that address right here. I keep pointing in the wrong direction. Right here, employmentlawyer.ca. Phone numbers there, email address is there. So Jenna, that's what he needs to do. But he can't wait on this. If he starts working in that sales role, after a couple of weeks, he loses his ability to pursue constructive dismissal. He needs to make that decision now, okay? So employmentlawyer.ca, Jenna, the way for your husband to connect with me, and I would do it today if possible. Okay, let's see. Next question from Darlene. She's on Facebook. My company has a policy of use your holidays or lose them, and they won't pay them out. Is this legal? No. So you can lose your vacation time. You can't lose your vacation pay. So what I mean by that is they may say, well, if you don't take your 1 week's extra vacation this year, you're not going to be able to take it later. That's okay. But they still have to pay you vacation pay, even though you're not taking that vacation. Okay. So if your company won't pay you the outstanding vacation pay, Darlene, for that, you can contact the Ministry of Labor or the Employment Standards branch in the province where you're working at. They can help you with that. And no, you can't lose vacation pay that you've earned, that you've accrued. Okay, great question, Darlene. Thank you for that. Lots of good questions coming in. Ask yours as well. Next question comes to us from Tanya. Can the employer ask you to bring in all your medical documents that allow your accommodation after being given it? I'm not sure what you mean. Medical documents that allow your accommodation after being given it. The only thing your employer can ask you is a doctor's note saying that you need accommodation. So I'm not sure what other medical documents you're talking about. You need a doctor's note that says, here's the accommodation that I need. If a doctor says, Tanya is my patient, she needs the following 3 accommodations, that's all that the company is entitled to get, as long as your doctor is very clear. So that's the only thing, Tanya, that your employer can demand. Thank you for that question. Okay. So Michael says a follow-up that my colleague said that the way I read this contract, the company would argue that it was only required to pay you 6 months base. So what happened, I guess, in your situation is you signed an employment agreement that limits your entitlements. So the problem is the law takes care of how much severance you're owed, unless you sign an employment agreement that says, forget about the law, I don't care about the law, I'm going to agree to something else. So you can contract out of your obligation. So it sounds like, Michael, that you signed an employment agreement that has what we call a termination clause that limits your entitlements. You may not have realized you were doing that, but you potentially gave up your severance in an employment agreement. That's why I've spoken so many times here on TV, radio, that you never sign an employment agreement without realizing what you're signing. And there's ways to negotiate those things, because then you can end up walking away and losing your severance. So it's nothing to, so it's not that my colleague told you that there's no laws in Alberta. They simply told you that you signed an employment agreement that gave up those laws, that by signing that agreement, you've told your employer, let's agree that the laws don't apply to me. Instead, what's going to apply is this document that I signed. So that's what happened in your situation. I'm only guessing that, obviously, based on what you wrote right now, but that's what happens with an employment agreement. So for everyone out there, be very careful with these employment agreements. You don't want to give up your rights in an employment agreement. So thank you for that, guys. I'm Lior Samfiru, the employment lawyer. I'm still here live answering questions. Still plenty of time. More questions are here. I'm going to answer them right now, but you have some time as well. You can ask your question. Give me the opportunity to read it and answer it, just like I've been doing. So let's get back to it. All right. Francis asks, I was injured during my probation period. After I healed and returned to work, I was told my probation period would now be extended as a result of the time away. Is this allowed? Generally speaking, yes, it's allowed, because the company needs more time to evaluate you. It doesn't really mean anything. As a practical matter, if a probation is extended, it doesn't do anything. It doesn't change your legal rights. So there's really nothing here that you need to worry about so much. I know people sometimes get very concerned when the company says we're extending your probationary period. don't stress out over it. It doesn't change anything. It doesn't give the company new rights. It's something that the company may do to make itself feel better, but it really is meaningless. So I wouldn't worry about that at all. Again, you can reach me through employmentlawyer.ca if you have any concerns. Let's see. Alexander asks on YouTube, I was recruited by a company away from my previous employer of 21 years, where most recently I worked as a sales manager. 1 week prior to starting with the new company, the owners changed their mind and they are now planning on downsizing their organization. They said that my services will not be needed. So as I understand that, Alexander, you had a job for 21 years, you were recruited away, so you quit that job, and now just as you're about to start the new job, they're saying, no, we're not going to need you. Can't do that. That's illegal for them to do. Well, it's not that it's illegal. What makes it illegal is the fact that now they have to pay you. In fact, they have to pay you in recognition of the 21 years that you had and that you lost because they told you had a job with them. So they could potentially owe you 18 months pay or even more, even though you never worked for them. So they made you a promise. In other words, they made you an offer. You relied on that offer to quit your job. Now there's consequences for them doing that if they pull that offer off the table. So Alexander, you need to contact me ASAP, okay? Myself, my team, you can do that through employmentlawyer.ca. You see that right here, employmentlawyer.ca. We'll help you with that. We've done many cases like this, and it's a good reminder for employees and employers out there is that if you quit your job because someone else offered you a job, if that second job doesn't materialize, there are consequences for that. Okay, the company that pulled the offer off the table will have to pay. Why? Because you lost something. In this case, Alexander lost a 21-year job. So definitely they're going to have to pay for that. All right, great questions today, guys. I just love the questions. Art has our next question. Art is watching us on YouTube. My brother's employer is shutting down the plant he works at and have told him he needs to move to a new facility. It's just under 2 hours away. Can they make him move to this new location? No, they cannot. Because it's so far away, he absolutely can consider this to be a constructive dismissal. So he has two options. He can either make the move and go to that new location 2 hours away, or he can consider this as a termination and get severance. All right, so those are the options. As I was saying to someone before, there's not a third option. So Art, he needs to call me, but he needs to call me now, as soon as possible. Not after the move happens, no gaps there. So he needs to contact me as soon as possible through employmentlawyer.ca. You see that contact information right there. Now, generally speaking, kind of an hour away is the threshold. For him, it's 2 hours away, so it's very straightforward. So he needs to contact me, Art, as soon as possible, employmentlawyer.ca. Let's see. Great questions today, guys. Cheyenne, who's also watching us on YouTube. Very popular on YouTube today. Cheyenne has the next question. I'm in Ontario, part of an entity being divested. I'm a management with 5 years experience. Offer at the new company is not as good in changing conditions. Do I need to accept? So obviously, I would need to see the offer. I want to understand how different the new offer, the terms of the new offer are from the old offer. If it's minor, it may be a situation that if you don't accept, then you may still be owed something, but it's limited. If it's very different, and if you reject it, you may be owed significant severance, and you've been there for 20 years. No, 5 years at this company. Sorry. So you potentially be looking, and if you're in a senior role, 8, 9, maybe even 10 months of severance. But the real key is for me to understand how different the new offer is from what you currently are doing. In terms of responsibilities, in terms of pay, in terms of potential, in terms of location, all those things are important. So I would actually need to read the offer and compare it to what you currently have, and then I can tell you. Generally speaking, if there's a sale of a business and you're being given an offer by the buyer, if that offer is different, you don't have to accept it. And if you don't, you are owed your full compensation, your full severance. But I need to understand why it's different and how it's different. So Cheyenne, definitely. For you, it's very important. Obviously, you need to reach out to me through employmentlawyer.ca. Again, employmentlawyer.ca is the place to connect with me. I actually want to read the offer and can connect with you there, right there, employmentlawyer.ca. Thank you for that, Cheyenne. Good question. And again, very important that we all understand our rights in these situations, especially if there's a sale of a business. It could certainly get a bit tricky. So we never sign anything. And good advice, okay, right now, never sign anything. An employment agreement, a job offer letter, a contract, without understanding what you're signing, what you're giving up. Frankly, don't do anything without sending me a copy first. Let me read it. Let me tell you what it says. And then you can sign once we understand what it does, or we can negotiate properly. It's often not that difficult to negotiate employment agreements, and I can certainly help you with that. All right, right now we still have some 10 minutes or so. You have time to get in your last questions. Whether it's a new question, a follow-up question, ask it. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, still here, still wanting to answer your questions. All right, next question from Sandra. I was told that as I work less than 20 hours a week, I'm considered a contractor. Is this true? It's the same place every week. I do not set my hours or schedule. No, it's not. Nonsense. The number of hours you work has nothing to do with it. If you have a job, a regular job, you are an employee. You're not a contractor. So Sandra, you've been misclassified. You know, a lot of people have part-time jobs. Doesn't mean that they're contractors. Yeah, you know, you may have a part-time job at the mall or at the store or at the restaurant. The fact that you have a part-time job, you work 5, 10, 20 hours a week, doesn't mean you're not an employee. Of course you're an employee. So the problem with being called a contractor when you're not really a contractor is that you're doing something, you and the company are doing something illegal. You're essentially telling the government that no, you're something that you're not. So I would be very concerned if I were you to do that. So probably best idea is let's talk about this. You may just want to tell your employer, I'm not going to do that. If you are going to do it, be very careful with how you pay your taxes. Don't try to get deductions because you don't really get those deductions. So no, you're still an employee. Okay, let's see. Our next question here is from Bubba. We did work and they shut us down early. Would they have to pay for the time that we didn't work? That was about 4 years ago. I'm a seasonal worker. So I'm not sure exactly what you mean, who they are and what the work that you did, but either way, unfortunately, you're out of time. Bubba, there's a 2-year limitation period for most things employment law. So if this happened 4 years ago, then you'll be out of time. Again, I don't exactly understand what happened there, but what I can tell you, if whatever it is that happened, it was 4 years ago, there wouldn't be anything you'd be able to do anything anyway at this point. So let's see. Continuing right now to answer some questions. Tanya just had a second question. Tanya asks, if the accommodation causes you to lose hours, does that become your new hours? No, not necessarily. So if the accommodation is such that you need to work less hours, once that accommodation is no longer needed, then yes, the expectation is you will go back to your normal hours, the hours that you had pre-accommodation. So if you need reduced hours because you're sick, because you have a disability, well, then that's what's happening. But you get better. Now you don't need that accommodation. You're healthy. You can go back to full-time hours. Then the company is expected to put you back to full-time hours. By definition, accommodation is something that happens for a specific reason. Once that reason is gone or no longer applies, then you're back to being the way things were before. Let's see. Next question on YouTube from Colcad. Is it all COVID-related wrongful dismissal in Alberta already resolved? We are waiting since October 2021. Because of age, we are unable to find another job. Well, I can't talk about all cases in Alberta, right? I can tell you that we, as a firm, we've resolved hundreds, if not thousands of those. We resolve them every day. So if you're not happy with what's happening with your case, the best advice I can give you is give me a call, give my office a call, and we can take a look at it and let you know what needs to happen, if something's not happening properly, and you know, why your matter's been going on since 2021. We've resolved more cases than I can count. A lot of people lost their jobs because of COVID. A lot of people also lost their job because of vaccine status. we've resolved a huge amount of these across Canada, frankly. So because of that, that's what I can tell you in this situation. You want to reach out to me. Now, this is also a good opportunity to tell everyone about another tool that you have to know about. Some of you have heard me speak about it before, and that is our severance calculator tool. If you want to know how much severance you're owed, if you want to know how much, if what the company's offered you is appropriate, it's very easy to do that. All you do is you go to pocketemploymentlawyer.ca. You see that address right here, pocketemploymentlawyer.ca. When you go there, one of the first things you'll see is our severance calculator tool. As the name suggests, the severance calculator, it calculates the amount of severance that you're owed. You answer 3 questions: your age, your position, and the length of your employment, and it's going to tell you if you're owed 8-month severance, 18-month severance, 24-month severance. It's going to calculate that for you. It's free. It's anonymous. It's been used for by over 2 million people across Canada. So the first place you go to, if you've lost your job, if you think you're about to lose your job, or maybe you're just curious and you want to know, hey, what would I be owed? Grab your smartphone, your tablet, your desktop, go to pocketemploymentlawyer.ca. You see that address there, and use our severance calculator tool. First place you go to, okay? Now you'll know. You won't have to wonder, hey, is their severance offer good? The company offered me 3-month severance. Is it good? Is it bad? Am I owed more? Am I not? You'll know. pocketemploymentlawyer.ca, there for you, free and anonymous, easy to use. Check it out for yourself. In the remaining time, we can still maybe get in another question under the wire. I want to answer an email that came in. Let's see. Nancy's email says, I've had to miss work on several occasions because of a medical issue that I am dealing with. My boss told me that if I miss more work, I shouldn't bother coming back. Can he do that? Absolutely not. It's a ridiculous thing to say. You don't control what time you need off for medical reasons. You can't control if you're sick or if you have a disability. It's something that happens outside of your control. You can't be punished because you're sick and unable to work. What you have to do is get a doctor's note. Whether you need to miss a day or a month or a year, have that doctor's note. And if the company doesn't give you that time off, if they punish you, if they let you go, if they consider you to have resigned, all of those things are illegal, okay? They can't do that. So don't worry about this idea, well, you can't take any more time off for medical reasons. Nonsense. What if I'm disabled tomorrow? I'm sick tomorrow. Too bad. You have to come in? Of course not. That doctor's note that you have is extremely powerful. It's really all you need. And the company has to abide by it. There's no choice here. There's no option. It's not something that's a nice thing for them to do. It's mandatory. They have to do it. So a very important lesson. And remember how important it is to have that doctor's note. Guys, I'm Lior Samfiru. I'm going to answer one last email before we'll conclude for the day. And this email comes to us from Fred. I got into an argument with my boss and was fired on the spot with no compensation. I've always been a good employee. And I have worked for the company for 5 years. Can I get my job back? So, Fred, unfortunately, you cannot get your job back. But what you can get is severance. The law can't make company usually take you back to work, but they can get your severance. And the fact that you got into an argument with your boss, even though you may have said a few things you shouldn't have said, maybe you kind of got a bit hot and bothered, doesn't mean that you can be let go without any severance. You would have had to do something terrible to not get severance, okay? Terrible. And unless that's what happened, you are owed that severance. So it's important to remember that just because you did something wrong, or maybe you did a few things wrong, does not mean that the company can let you go without compensation, without severance. So yes, Fred, you're going to be owed severance. You need to reach out to me through employmentlawyer.ca. Can't get your job back, though, usually. The law does not have the ability in most cases to make the company take you back. It can simply order the company to compensate you by way of severance. Guys, this is the time that we have for today. I'm so happy you guys joined me today. Great questions, as always. I loved answering them. I'll be back next week to answer more questions. But please don't wait until then. If you have a question, an issue, some help that you need, you can contact myself and my team now, today, through employmentlawyer.ca. Again, employmentlawyer.ca, the place to go to connect, get answers, and actually get help. Guys, always a pleasure. Again, I'm Lior Samfiru with Samfiru Tumarkin LLP. Thank you so much for joining me today. I'll see you again soon, and don't be ashamed and don't be afraid, and don't even hesitate to reach out with any issues or questions. Thanks, guys. Take care.